Hi, I'm Ineke van der Broek, a commercial contracting lawyer at AKD. I advise companies on entering into and structuring international commercial contracts. In this series of 8 online videos, I will point out the potential stumbling blocks and pitfalls that international trade partners need to be aware of when entering into commercial contracts. One example of a commercial contract is a distribution agreement, but there are many other types of commercial collaboration, such as a production agreement or a technology transfer agreement. In each and every episode, I will not pay much attention to the strictly legal aspect of contracting. Instead, I will focus more on its practicalities. In this first video, which is split into 2 parts, I will address the objective of the collaboration, choosing the type of collaboration, and the importance of correctly classifying the agreement that you want to enter into. In the second part, I will come up with some pointers to help you get to grips with negotiations for an agreement. In later episodes, I will discuss a number of specific commercial contracting clauses, such as the liability clause, guarantees and conformity, the termination clause, the choice of law and form clause, and IP, IT, and privacy provisions. My final video will be about setting up a sales network in the EU for companies established outside it. You have a company and you decide to enter into a commercial collaboration with another company. Before starting negotiations about the merits of your collaboration, you do well to get the facts straight on the following questions. In what markets are all parties involved active? What products, goods or services will be supplied? Who's your business partner across the table? And what are the parties' objectives going into this deal? You are also well advised to determine for yourself what your interest in the collaboration is and what intellectual property rights, technology, patents, trademarks you own and want to protect. If you are clear on each party's objectives and the interests at stake, it will be easier for the parties to define the type of collaboration that they wish to implement. In the context of a resale agreement, for example, a pertinent question would be what kind of distribution system both parties have in mind. If the supplier aims to maximize the number of suitable retail outlets with a view of achieving the highest possible turnover and market share, the supplier could benefit from an intensive distribution system. Are you a supplier of luxury products or products sold under prestigious brands, and you want to protect your brand? If so, a selective distribution system would help you to control the resale channels for your products and avoid harm to your brand image. Another option for you as a supplier would be to allocate specific territories or customer bases exclusively to a select number of distributors. You will have a clearer picture of your business partner's intentions if you take time to study their background and culture. In this world, awareness of diversity and its importance is growing at a steady rate. More and more companies want to do business with other companies that are diverse and inclusive. Do not underestimate cultural differences as you do business. Study your intended business partner closely, their background, their culture, their motives, their values. If you have knowledge of the local culture or are able to identify yourself with your business partner, you will create more trust. A relationship built on trust may result in your business partner opening up and sharing relevant information about the proposed collaboration and themselves. Set aside time to learn which behavior and use of language is appropriate when conducting negotiations. Would a direct style of communication, which we value in the Netherlands, be desirable, or would it in fact be considered impolite? Before engaging with the other party on the substance of the agreement and sharing confidential information as part of the process, it would be recommendable to conclude a non-disclosure agreement or NDA. The purpose of the NDA is to ensure that the information that you do share is treated with confidentiality and not disclosed to others. If you just want to negotiate without engagement about the possibility of a collaboration, it makes sense to include in the NDA an explicit clause to that effect. If that's the case, you should steer clear of expressing that your intention is to negotiate a specific agreement. The idea behind this is to avoid not being able to break off the negotiations without consequences, such as an obligation to pay compensation. If, for example, the other party has legitimate expectations that an agreement will be concluded. So what if you do want certainty of concluding an agreement or achieving another goal? Well, then you can draft a binding letter of intent and use that as a step plan of action to accomplish the party's objective, like negotiating an agreement. This is a good way of eliminating uncertainties and limiting risk. In this part of the video, I discussed the importance of setting out the parties' objectives and intentions for the proposed collaboration before entering into negotiations. You will have a clear picture of your business partner's intentions if you take time to study their background and culture. In the second part of this video, I will address the importance of recording the parties' intentions, how to do so, and the importance of correctly classifying the collaboration. See you next time.